Okay, thank you, Anastasia. Hello, everybody. I'm really delighted to have been asked by your people to talk to you about this subject, which is an absolutely vast network of legal rules and regulations that operate around most of the world. So, and that's a big challenge for us to do, and for me to convey to you within the time scale we have. I want to start by not introducing myself, because that's been done, but just by running through these slides, by explaining to you that I'll be using these slides as literally a PowerPoint, literally to provoke me to say things to you, to explain things in an extemporary way. So this is not a traditional kind of student or university or high school lecture. It's a talk by me to you about try to convey your understanding of the very complex issues involved in relation to visual art around the world and copyright. If you, as Anastasia's probably said, if you have any questions, or you can, in English, if you unmute yourself and ask me as I go along, that will be fine, rather than you sitting there and waiting for 2 hours with a break and then asking questions right at the end. I'd much prefer if we do it as we go along. Or for those of you who prefer to write something and use the chat facility, then Anastasia will be monitoring that and let me know what you are saying. Okay, so that's the way I hope to approach this with you. So let me move into the first slide. I'm using this first slide to use the English word copyright, or the French translation of copyright, which is le droit d'auteur, as you can see. And le droit d'auteur is a much more, I think, modern and accurate description of what we're talking about here, because le droit d'auteur translates better than copyright into the way it works, which is the author's right. So it's legal rights of the author. In our case, we're talking about the artist who creates the work. And the rights are more than just rights to deal with somebody who literally copies something, like puts it in a photocopier or in an Epson scanning machine. It's not just about that. It's about the way in which original work made by an artist may be used in a way that's not just simply copying it and therefore merchandise it or communicating it in some way. It deals with other uses. And what I want to do is just start with a developmental context about what the rationale, as using that French word, the rationale is, what's the reason for the existence of these rights that artists have, or the authors, and including visual artists, have. The rationale is these rights, so-called authors' rights, are about money. Okay, it's really, crudely, it's about money. The rationale is behind the law that gives you these rights is about money. In other words, if somebody takes work that you've originated, you've made, and starts to use it in some way that generates money or income for those other people, and they haven't got your permission, the rationale is to say, no, you can stop them, or you can get some money to be paid for whatever use they want to make of it. That's the rationale behind it. And it basically started because of the Industrial Revolution that happened largely in the Western Europe, in England in particular, in the 18th and 19th century. So that the first copyright laws or authors' rights laws were passed in England or in the UK in the year 1710, which was at the beginning of the 18th century, because technology had happened since the 15th century with the Gutenberg printing press that enabled things to be reprinted, including not only words, but also visuals, which could be reprinted. And by the time of the beginning of the Industrial Revolution, printing was not just capable of being done by hand using the old original printing machine, but also by using other mechanical technologies. So images could be reproduced quite quickly, as against them being a very slow process, say in Albrecht Dürer's day, during the Northern European Renaissance, where it was mostly done by hand. But industry could make multiple reproductions of things. And that's why the English passed the original crude laws, which said, if an image is made by an artist and someone else wants to reproduce and print and sell those prints of the artwork without their permission, the artist must have a legal right to either stop them or claim some money from them. And that's what the crude origins were, 200-300 years ago. And the idea of giving artists a limited right, in other words, it's limited for a limited period of time, so it's not forever. The idea was to give artists enough time to have these rights to generate some income from their work being used out there in the marketplace, so that the income could kind of support the artist to enable to continue with their own creativity. So that's really what it was about. The rationale was about technology, yes, mechanical reproduction, yes, the Industrial Revolution, yes, but also about giving artists the right to have some income that would sustain their further creativity. That's the rationale behind it then, and the rationale behind it now. That's what it's mostly about, okay? And we're going to look at how that works internationally, because the idea of these limited authors' rights spread from England in 1710 right around the world. So that today, what we're going to look at today is the way in which it operates around the world, which is what I've been asked to do. So that's the rationale behind it. And my next bullet point takes us to 1886. I'm going to move from this very quickly to the modern day, to today. But in 1886, the developed world already had copyright laws for their authors. But the problem was that all those laws were different, and that they operated in different ways for different lengths of time. And those laws only applied within the countries that passed the laws for their artists. So in France, those laws applied only to French artists in France. The problem was that communications around the world by 1886, because of the Industrial Revolution, communications were getting very, very wider and more rapid. And so the problem was, if an artist's work was being reproduced without permission in Belgium or Germany or Scandinavia or in England or in the USA, or dare I say in the Ukraine or whatever, then it would be a problem for French law to operate in those other countries, and the artist couldn't do very much about it. So, if anything. So those countries that had these laws came together at Bern in Switzerland, and they developed an international agreement, which still operates today, which is called the Bern Convention. It has a longer name, I think it's Berne Convention for the Protection of Authors' Rights. And it still operates today. International treaties usually have the name of the city or the place where they were originally signed, and they were originally signed in 1886. And what the Berne Convention did was solve those countries that signed the convention two main problems, and the solutions are with us today. So that's how international framework for copyright operates today, because of the way in which they solved the problems facing them in 1886. And the two problems was the one I've just briefly explained to you about France and the author's rights. I'll just say it again in a different way. Each country gives its artists automatically, as soon as the work is created, as soon as you make a work, the law of your country gives you the rights, which are, I'm calling copyright or the author's economic rights. Okay, and you can exercise them for a limited period of time. We'll talk about how long that is. But those rights only apply to you in your country. So what the Berne Convention did was to say, first of all, let all the countries that signed this convention have the same or similar rights within the laws of their own country. So there was a kind of uniformity or a kind of harmonization of the kinds of rights that were given, the kind of length of time that they operated for, the kind of protections that you had as an author. But they also said there can be minor variations within each country if they want to. We'll leave it up to each country. But basically, the same basic and fundamental and strong rights will be the same or very, very similar. So that's the first thing they did, which is basically saying, let's all have the same or very similar rights for our artists. Fine. The second problem they had, which is what I've also referred to, is that the rights given by any one country to its artist citizens couldn't be enforced in foreign countries. And what they agreed was to say that they would write into their own country's law that they would enforce the rights of foreign artists from countries that had also signed the Berne Convention, on the basis that all those other countries that signed the Berne Convention would give similar rights to the artists from other countries that signed the Berne Convention. That sounds a bit abstract. I'll just say it another way. There's a word that we use in the English language, which all of you may or may not be familiar with, which is called reciprocity or reciprocal enforcement. So it basically says, if we pass laws enforcing the rights of your artists in your foreign country, will you enforce the rights of our artists in your countries if they need to? And the answer was, everybody in the Berne Convention signed up to that, and they still signed up to it today. So basically, if, like Ukraine is a member of the Berne Convention, you out there listening to me have these rights given to you by Ukraine law whenever you make a work automatically. And those rights of yours can be enforced if you get somebody abusing your work in a country beyond the Ukraine. You can enforce your rights in those countries to get some money or to stop it, so long as it's a country that is also a member of the Berne Convention, because they will have passed laws saying we will enforce the rights of artists from countries that are members of the Berne Convention. So that, for example, if your Ukraine artists had your works abused in the USA, for example, and somebody was merchandising and making money without your permission in the USA, you could hire lawyers or hire lawyers in the USA to take legal action to stop it and to get you some money in the USA. And the first thing the lawyers would do was say, this person from this artist from Ukraine has a legal right to make this claim because under the Berne Convention, which the USA government and law embraces, has a legal right to bring the action in the USA for abuses that have happened in the USA because Ukraine is a member of the Berne Convention. So those two problems were solved in that way and are still with us today and have become the way in which all international property law, not just the copyright, but things like trademarks, things like design rights and other things that we're not talking about today, are enforced around the world by solving those problems through international conventions. Anastasia, I think I'm going to pause there and just, I know I've said a lot. I tried to explain a lot. Just in case anybody's sitting there going, my goodness me, what the hell is Henry talking about? So somebody might have a question if they haven't understood what I've said.
Скажіть, будь ласка, чи є у когось запитання до пана Лідіейта на даному етапі? So we do not have questions so far.
Okay.
In case we will have some, I will let you know.
Okay, fine. Thank you, Anastasia. So I'm going to carry on. I can, if you've all understood that, that's why I paused. I can build on this very, very quickly, and we can move into, well, how does it work? All work today. The reciprocal arrangements that I've talked about, there's one fundamental rule within the Berne Convention, which is this. If you, a Ukrainian artist, want to make your claim in the USA because somebody's making a lot of money out of your artwork without your permission, under the Berne Convention, the USA courts, if necessary, will enforce your Ukrainian rights in the USA using USA law, not Ukrainian law, using USA copyright law. But within that law, there will be no less favorable treatment. That's a phrase that the Berne Convention uses. No less favorable treatment of you than America would treat an American artist. So in other words, they would treat you not less favorably. In other words, you wouldn't be just treated as a foreigner, you'd be treated as if you were an American bringing a claim using American law. That's what the Berne Convention's done, which is brilliant. So if a country signs up to the Berne Convention, then you will be treated no less favorably by American law than an American artist would be treated. And the reason why they do that is because Ukraine is a member of the Berne Convention. I'll just pause there. I won't do it all the time. Anastasia, if anybody doesn't get that, because it's quite a complex thing to explain.
Yes, I'm asking the audience in the chat whether they have any terminology that needs to be explained more in details.
If somebody does say something, okay, I'll move on. Sure. And so what's happened from 1886 to today, there have been continual improvements and revisions and changes to the Berne Convention. And then when all the countries get together and say, let's change it, let's improve this, all the countries then go back home, as it were, and change their domestic laws to comply with what they've all agreed to change. And one of the major revisions, one of the major changes to Berne happened as a result of changes to the whole of society in the 1980s. And the big change that happened was digital technology and the internet and obviously we're in the post-digital age now, but the introduction of digital technology impacted very, very powerfully on artist rights, because up until the mid-1980s or early 1990s, all the rights that I've been talking about were all about mechanical reproductions, which is why I was talking to you about the Industrial Revolution, of artist rights. We're all saying if there is a mechanical reproduction and use of artist's work, then these are the rights to stop it and so on. And what happened was from the mid-1980s, roughly, to the night, as the countries began to see what the impact of digital technology was going to be, the Berne Convention was amended, and it was amended, and all the countries agreed to the amendment to say, we're going to not only give artists rights over mechanical reproductions of their works and uses, but we're also going to give them rights over digital reformatting of the images of their works, so that any scanning, any copying, any pasting, any uploading, any downloading, any streaming, any of all the things that we now take for granted, all those things are included as abuses of the artist's right not to be damaged economically by the use of their work. So uses of their work could be mechanical or could be digital. And there are some further related treaties and conventions which have modified the Berne Convention and have supplementary provisions in them, but I'm going to embrace those in what I take you through further. So that point is about national implementation and variation. So in other words, each country goes away and implements within their national laws whatever they've agreed at Berne, and Berne allows some variations for countries to make some variations if they wish, but that's allowed by Berne. Okay, so that's why we have, and I can talk about to you, an international framework of authors' rights or visual artists' rights, I'll call it, around the world, because what I'm taking you through is the way in which Berne has been implemented throughout the world, including Ukraine. But I'm not going to talk about any major or significant variations over the 200 or so countries around the world that have minor variations. I'm talking to you about the fundamentals of how it works in these sessions today. There is usually no definition within the laws of what authors' rights are. Usually what the laws do is take the lead from Berne and say, when artists are given by the law these rights over their works, has somebody unmuted themselves? Got a funny noise.
Alex, can you please unmute yourself? Thank you.
Thank you, Anastasia. So what usually the laws do, invariably, there may be variations on this, is that it says if an artist makes a work, and I'll talk about a work, what kind of work are we talking about in a minute, the rights that the artist gets automatically, in other words, the artist doesn't have to apply to anybody, to the government or anybody else and say, can I have my artist rights? Under Berne, every artist gets their rights as soon as they've made their work. I mean, that's a very important point to take away. Okay, you don't need to ask permission. Do I own author's rights or copyright or whatever over this work? Well, did you make it? Yes. Well, then you have the rights. Why? You're a Ukrainian citizen and Ukrainian law gives you those rights right now. You don't need to ask anybody. But the rights that you get are usually not defined except by saying the artist has the rights. In other words, what's called the author's rights owner has two bundles of rights. If you can see my hands there, one bundle is the rights, what we call the proactive rights. The proactive rights are the rights to use your rights to go and reproduce digitally, mechanically, and to merchandise and to communicate and to upload and download and have things used on merchandise and make things and make money for sale. You can be proactive because you have the exclusive rights against all the world. You're the only person, because you're the author, who can authorize yourself to use these rights to make use of the work in a commercial way if you want to. Those are what we call the proactive rights. But the other side of those proactive rights, if you can see my hands up there, the proactive rights up here, there's the other side of those rights, which are called the reactive rights. And the reactive rights are that the artist maybe hasn't used any of their proactive rights. They've just made the work and it's been exhibited, or it's online maybe, or you've sold it to somebody and they've got it in their gallery or in their room or whatever it may be, and it can be seen. The reactive rights are basically the mirror of the proactive rights, but the artist doesn't actually do anything to reproduce a merchandise. Somebody else reproduces and merchandises without their permission. And so the artists have the right to react to what someone else has done, to stop it, and to use the law to say, I have the right to do this, not you. Can I stop you? And I use the law if necessary, or I want some money if you want to carry on. So there's the proactive, you can positively go out and do something, or there's the reactive, where you can basically, as I think the American phrase that they use is to cease and desist. Cease and desist. Hello, you're merchandising my work without my permission. I want you to stop, to cease, and I don't want you to do it anymore. Desist. So those are the rights that are given to be proactive or reactive or both. Okay. I often say to artist clients, those rights enable you often, whether you're proactive or reactive, to earn money when you're asleep. Okay, just stop there. You're asleep. You're not doing anything, but somebody else is doing something to make money using your artwork, in which case you can just be asleep. And then you can say, hello, I want some money, or you can do it yourself by authorizing someone else to go off and make some money for you. Okay, the one most important thing to take away here on this slide, and probably today, is that what these rights do not do, they do not give you any rights over your ideas. Pause. What the hell is he talking about here? Come on, Henry, explain yourself. Copyright or author's rights internationally do not protect you, give you rights over your thoughts, your ideas. In other words, what's the best way to keep a secret? What's the best way to keep a secret? Answer, don't tell anybody. So if you have a great idea, don't tell somebody else you've had a great idea and let them execute your idea and implement it and go running off. And you say, well, they're making loads of money out of my idea. Well, how can you prove that you told them what your idea was? No, what the law does is to say, if you have an idea for an artwork, or you have ideas for an artwork, or for any creative work, what the law can do is give you rights over it if you express your ideas in some tangible form, whether it be digital tangible or whether it be physical tangible. In other words, as I said to you before, what the law steps in and gives you these rights over your work when you've made your work, not when your work is still in your head. It can't do that. And that gets into a problem where you make a work expressing yourself, expressing your ideas in your visual artwork. Somebody sees it and then says, that's interesting. I like the idea behind that. And they take your idea behind what you've expressed and they make something else, which is not a copy or a replica or a rip-off of your artwork, but it might be using your idea. So the idea, for example, of cubism developed by people like Picasso and Braque doesn't stop other artists executing cubist work or impressionist work done by the impressionists from the 1860s onwards, and so on. Or the idea of, was it, you would know better than me, was it, it wasn't Mantegna, it was, who was it, who did perspective, discovered perspective through the Italian Renaissance in the Quattrocento. Anyway, when perspective was discovered and started to be used by people like Mantegna to do Dead Christ and all that stuff that we know, nobody could say, I have the idea for perspective, no one else can use perspective. It's ridiculous. So the law it can say, I had the idea for creating 12-bar blues. No one else can make 12-bar music with 12-bar blues. Get out of here. You know, the law says we can't do ideas at all. So the most important thing to take away is to say, if you have a great idea, don't tell anyone, keep it a secret, or execute your idea before anybody else. Okay, and that's quite problematic. The next slide, which I'm going to be able to move on to, and then we can move on quite quickly, I'm going to give you, is there was a young artist client who came to see me recently and was worried that her work was more conceptual than it was physical. In other words, it was the idea behind what she was doing. I can't name the artist. You probably know who it was when I said, but anyway, she said, right, my ideas are more important than the actual artwork itself. And we talked through whether she had any rights and how to protect them and all that stuff. And basically, at the end of the day, what I was saying was, you've got to get, if you've got these great ideas, just execute them before anybody else. And once they see the ideas behind your work, then they can use your ideas if they want to. Okay. And we spent a long time with me explaining what I've just tried to explain to you briefly. And she sent me an email saying, thanks very much. I think I've got it. I think I understand it. Okay. And I'm attaching to this email something that demonstrates that I've understood. And this is what she sent. And I looked at it and I sat there and I'm going, how does this demonstrate that she's understood the idea point? So I rang her up and I said, I don't get it. You've sent me this thing. I know you're an ideas artist and all, conceptual artist and all that stuff, but I'm really being dumb here. I must be really stupid. You know, she said, no, Henry, it's a PowerPoint. It's animated. Just put it into whatever and click. So I clicked and this is what I found. Hopefully you can see that little beaver in the left-hand corner. So she said, yeah, and click again, Henry. I said, yeah. She said, now click again. So I know it's kind of like that school child humor, but I thought it was really good because she got it, and that was it. Okay, it doesn't matter if somebody makes something using your ideas, as long as they don't actually make an artwork that looks like or is derived visually from someone else's work, from your work. Okay, so that's what the idea. It's often called in the jargon of these, the legal jargon of these things, it's often called the idea expression dichotomy. I'll say that again, the idea expression dichotomy. And if you want to go and do some research into the idea expression dichotomy, there are many, many artists and other intellectuals who've looked at the idea of, looked at the issue of the idea expression dichotomy, because it's a very interesting and challenging conceptual point. So, for example, just before I move on to talk about really more boring matters and nuts and bolts, it's often asked of me things like when Duchamp, Marcel Duchamp, used found objects 100 or so years ago, and did those things which are now called ready-mades. I'm not talking about the bicycle wheel on the stool. I'm talking about, say, a found object like the fountain, or I don't know how it translates, you know, the famous 1917 fountain by Armat. You know, he bought it from a plumber's merchants in New York City and put it on a pedestal. It was a found object. Well, he didn't actually make it, but it was his idea. So what the law would say probably is nowadays is would probably say, well, the idea of using a found object, anyone can do that. You can go off and put, you know, something else on a pedestal and put it in a gallery and say, this is my art, whatever. That's entirely up to you. You can't protect the idea. But if somebody kind of gets a urinal, just like Duchamp, and puts Armat 1917 and puts it on a pedestal so that it looks like, then maybe they've created an artwork which is actually derived from the artwork that Duchamp put together. Or if you put a bicycle wheel on a stool painted white. So that's a very interesting and challenging area about the protection or not of ideas of visual artists. So moving on, this one, you can expand it when you see it either now, or if you get the PDF that I'll send to, of these slides, I'll send to Anastasia for you. But this I've taken from the Bern Convention website. All those countries in blue are the countries that have signed up to the Bern Convention. As you can see, it's most of the world, which is absolutely brilliant. Here we are in 2020, and in 1886, it was like half a dozen, 6 countries. Now it's nearly everywhere. So there's only 20 countries, and they're listed there, that have not been able to sign up to the Bern Convention. So in other words, you can see Ukraine is there, and obviously, from what I'm saying, and therefore any citizen of any of those countries in blue can enforce their rights that they get from their own countries in any of the other countries that are in blue. That's really what it's about. Somebody has been marking up the screen, Anastasia. I don't know whether you can see that. My screen.
Yes, I can see somebody wrote something.
I don't know how they've done that, but yeah. whoever's doing that should take it away and stop doing what they were doing.
Скажіть, будь ласка, хто залишає відмітки на екрані?
Ah, now it's gone. Thank you. Whoever did that, thank you. Well done, Anastasia. Okay, let me move on. So what we need to break down and understand now is which works, in other words, which artworks are protected, because not everything that you make as a visual artist is protected. So this slide kind of gives you a summary of the kind of protections against visual artists that you have, the kind of rights that you have. I'm calling it protected works. In other words, what kind of works are protected by the law? In other words, what kind of works can you make that give you these rights? What the law does not do and tries not to do is to say whether these rights will only be given to artists who make works that are good works of art. In other words, laws around the world, around the Berne Convention, do not say only artists that make good fine art work are protected. If the work is bad or is indifferent or not very good, we won't give them these rights. The law is completely neutral about whether or not there are any rights. So in other words, if you make work that's good, if you make work that's bad, if you make work that's neither good nor bad, indifferent, the law doesn't care. The law is completely neutral, because what the law does is to say, did you make the work in a form, in a medium that the law can recognize, irrespective of the qualities of the work? Let me explain. Anastasia, someone else has put some blue dots on their screen that is coming through on here, which is distorting my white slide.
Okay, I will let our technical specialist know to block this function.
Yeah, okay. Thank you, Anastasia.
Thank you for noting.
Okay, what I've done is I'm doing a category. In other words, the law classifies or categorizes the types of mediums that the law will recognize as being automatically given these rights. So in other words, do you make still, what I'm calling still, that in other words, I'm talking about visual art that's not moving, okay? So it's not about the moving image, because if you make images that move, they are called, as the Americans call them, movies, and therefore, like cartoons or animations, if they're movies, then maybe the law gives authors rights under the category of film and video, which is not the same as still visual art. In other words, visual art that doesn't move. And usually the laws of most countries say there are traditional forms that the law recognizes. Paintings, obviously. So those are the basic 6 traditional forms that over the centuries the law has broadly recognized. Okay, so if you make a work in any one or any combination of those forms, then it will automatically be protected, and therefore you will have the rights. However, what most laws do is make a distinction between those forms of visual art and other, forget about Star Wars, I'll explain that in a second, other 3-dimensional objects. So there may be works that are made as fine artworks, as artworks, that are not paintings, they're not sculpture, not graphic, not photographic architecture or collage, but they are three-dimensional. They are objects, physical objects that are made that may well be protected because they are art objects. In other words, it may well be like, what can I say? It's like, in other words, there's not a defined set of forms. There's a broad category that says other three-dimensional objects that are art. In other words, ceramics, jewelry, furniture, it may be sometimes clothing. So in other words, there are lots of, you can think of other things that are other three-dimensional objects that may or may not be artworks. And mostly, what most laws do is to say, if those three-dimensional objects like furniture or like clothing or like shoes or like watches or like accessories or ceramics, if they are made by way of mass production being by an industrial process, they are produced in large numbers, and it depends on, each country can decide what is large in number. In the UK, for example, or in Europe, generally it seems to be around 50 objects or more. If they are industrial, not handmade, but industrially made, then those works are usually excluded from artist copyright because they are not given the protection of an artist copyright. They are given protection usually under other intellectual property laws, which are laws relating to trademark and industrially produced designs. So that's what I mean by, I'm just broadly saying, other three-dimensional objects. So
Henry, I'm sorry to interrupt. We have a pop-up question. What about music instruments and acoustic sculptures? So by that, music instruments made by artisans.
Yes, if they are not mass-produced, they're handmade, they will be protected as artworks. Yes, under the laws of most countries. But then it gets to, was there anybody else, Anastasia?
No, that's not the question so far.
But forget about the Bridgman, so forget about Star Wars and Bridgman for a second. But the final thing, which relates to, Anastasia, that previous question, when I said, you know, in principle, yes, it's an artwork if it's handmade. But most laws under the Berne Convention require traditional forms or other three-dimensional objects like the violin or the cello or musical instrument to be the shape and form and configuration and perspective to be original, legally original. And what the law means by that is, yes, the artists will get protection if they make a work in those either traditional forms or other three-dimensional objects, but only if what they've made is original, meaning that it is not copied or significantly derived from someone else's earlier work. So in other words, the law requires the artist to make something not based on some earlier artist's work, however earlier it is. It might be 3,000 years old. It might be an Etruscan ceramic or statue, or Roman or Greco-Roman, you know, like Victorious Youth by Lysippos. But if the shape and form and configuration of what you today have made is based significantly upon someone else's earlier work, however earlier it is, then the law will say you cannot have any of these rights because it only applies if you make something that's your own original form of expression and not substantially and significantly based upon someone else's earlier work. and Anastasia, what that means is, if somebody hand makes a violin and the shape of the violin is basically based on the traditional shape of the violin, it probably won't have the protection as an artwork because the shape and form and configuration is fundamentally based upon some earlier development of that shape and form and configuration. So if the shape and form of the musical instrument is unique, no one earlier, it's not based on any earlier shape or form of configuration, then maybe it can be protected as an artwork. So originality is key to this. Before I give two examples of Star Wars abridgment, I just want to pause there in case anyone else has got any questions.
Yes, we have two more questions. So one from Alexander. Alexander, would you like to unmute yourself and ask a question aloud?
Okay, yes, hello.
Hello.
Thank you for your lecture. It's really interesting. And I also have a question. Collage art used parts of other artworks, photos, graphics, etc. Where is the border between collage art and copyright breaking?
Yeah, I'll be talking, a good question. I like your question. You're ahead of me because after the break, we'll do things that the law allows to be done, usually allows to be done by quoting or using elements of other people's work, not significant parts of it or the whole of it. I think that's what you're driving at, aren't you? Alexander?
Yeah.
Isn't that what your question is about? If you use elements of other people, yeah, okay, I'll talk about that after the break. Good question.
Okay, great. And we have another question from Aleftina. Could you please point out the variations between countries beyond Berne Convention? Are there any difference in regulation?
No, I can't because I'm not an expert on countries beyond the Berne Convention. What they do is entirely up to them. And I've never dealt with any artists from any countries beyond the Berne Convention.
Okay, thank you.
No. Anastasia, sure. My question was actually, as I understood, that there are some variation between countries which actually signed this Berne Convention. For instance, France and Ukraine.
So which have signed, so not beyond the Berne Convention.
Sorry.
Okay. No, I understand. Okay. There are variations. For the purposes of today, I am going to talk about, I've selected the things that are most significantly different, but they're mostly, what I'm talking about today is the common features of all the countries. Where there are variations, they are variations beyond the scope of what I'm talking to you about, because it would take hours for me to talk about the differences, the minor differences between France and the Ukraine, or the Ukraine and the UK. I mean, you know, have you got the next 6 years to talk about it?
Okay, thank you. And the last question, we have it from Denise. Denise, would you like to unmute yourself?
Okay, my question, sorry. When, you know, the music instrument hung, it is registered in Bern, in Switzerland, and they register it as a music sculpture, but it is based on traditional music instruments and derivates from other national music instruments. So you talk that the music instrument shouldn't be mass produced, but they mass produced it in more than 1,000 copies. And what should we do? And now they are trying to suit everybody around the world when somebody is trying to make the same instrument. So
yeah, I understand.
You can comment something.
I understand. Okay, I understand what you're saying. You've explained it very well. Okay, let's take what you've said and what I've said and try and fit it together. And I'll do this as briefly as I can. Okay, from what you say, the instrument is not handmade, it's mass produced. Therefore, under the general copyright laws under Bern, it will not be protected as an artwork. That's absolutely certain for sure, because it's mass produced. That's it. So it doesn't fall into the category of other 3D objects. However, what's happened is you're talking about the design for it has been registered somewhere. I think you said somewhere, wherever it is. What that is about is if there are objects that are three-dimensional objects like you've described, or others, there is other intellectual property laws beyond artist's copyright, because that doesn't apply, where you can register, like registering a trademark, or you can register a design in a country, either for the whole of the world or Europe, to say, I am going to register this design, which is industrially mass produced, for a limited period of time, usually something like 20 or 25 years. And I have a monopoly over that design against anybody else in any country where I have registered that design. So in other words, your question has taken us into the area of registered designs of objects, which is not what this session today is about.
Okay, thank you, I understand.
Okay, good. Anybody else? Anastasia?
No, that's all.
Okay, I'm just going to do Star Wars and Bridgman, and then we'll have our break. Anastasia, I'm looking at my clock. Is that okay?
Yeah.
Why? Okay, just remember, guys, that Star Wars is an example, and Bridgman, they're both lawsuits that illustrate the point or aspects of what I was saying about objects and about originality. Okay, so it relates to classification. There was a lawsuit brought in the USA, you can see there, by Lucasfilm. Now we all know, da, 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 da. Okay, that's Lucas. And Lucas brought a lawsuit against actually an artist who was based in the UK. And the artist had a business that he traded in making artifacts and costumes and objects for use in films, whether it was weapons or armor or whatever it may. And this artist made the molds for the armor for the stormtroopers for Star Wars. And he did that when Lucas moved to the UK in 77, and to make his film, mainly Star Wars, was made in the UK. And he hired this artist to make the stormtrooper uniforms to a design, an artwork design, a sketch that Lucas and a colleague of his here had sketched out. He sketched out all the way Obi-Wan Kenobi would look and the way Luke Skywalker and all that stuff. And this is how he wanted the stormtroopers to look. So the artist made molds, and then plastic molds were used to make the stormtrooper uniform, which were used in the film. Fast forward from 1980 to around 2000, 2006, so in other words, 20 years later, this artist decides that because of the internet, he wants to offer a merchandising venture through the internet that says, if anybody, collectors out there, want the original stormtrooper uniforms that were made for George Lucas, I have the original molds, and if you send me your money, I can use those molds to make them and send them to you. So he was developing a business in that way, not a massive business, but a business. So Lucas tried to use copyright law in saying USA is a member of the Berne Convention. I have USA rights, and this guy is in the UK and they're a member of the Berne Convention. So first of all, I'm going to actually bring a lawsuit in California, which is, you see that one there, which he did. And of course, what happened was he brought his lawsuit for breach of copyright and said, you've violated my copyright, I want some compensation. And the artist didn't turn up, didn't send a lawyer along, and there was a judgment by the court in Lucas's favor, awarding him something like $5 million in compensation damages, whatever. The problem was that, what did Lucas do then? Because the court order didn't really have any effect on this artist in the UK. What he should have done is what he then did. He brought another lawsuit against the named artist a few years later in the UK. And to cut a long story short, he brought his lawsuit saying, let's use UK law. I'm a member of, I'm a USA artist, citizen. I have rights. Using UK law, I want to bring a lawsuit against this artist, and I want you to find violation of copyright and order him to pay compensation to me. So I want him to stop and I want him to pay compensation. The big question, you can see the reference there is UKSC, which is the UK Supreme Court. It went all the way up to the Supreme Court of the UK. And it was decided there, the question was, are the stormtrooper uniforms art or just other three-dimensional objects that are mass-produced or were mass-produced and are not art? So they may have started out as graphic drawings, and they may have been interpreted by this Ainsworth guy, this UK guy, to create the molds in his own way based upon the drawings. So Ainsworth wasn't claiming that he was the copyright owner in the molds that we created. Ainsworth was just saying, you have no claim against me under copyright because these stormtrooper uniform designs are not art, and therefore there's no copyright. You've brought your claim under copyright law, they are not art. And that was the issue. The issue was, for the court, was to say, are they art? If it's art, what can they be? They can only be sculptures. So are they sculptures, or are they other mass-produced objects that are not sculptures? And eventually, I asked you to decide. I mean, I know I put it in a crude way, a simple way. Are the uniforms made, mass-produced for use in a film, art, sculptures, or are they just mass-produced other objects, which could be protected under other areas of law, like trademarks and, like we were saying, the instruments, design rights, or whatever. But the narrow point is that Lucas put all of his energies and all of his arguments into saying, this is art and it's sculpture, and I own the copyright, and therefore it's a violation of my art. And remember also that this lawsuit was brought more than 30 years after the film. The first film is the first Star Wars film, A New Hope, episode 4. So, because under the other rights that I was talking about with the musical instrument, he did register his rights to merchandise the uniforms and the little, you know, Mattel little dolls of all that, and the Millennium Falcon and all that stuff you could buy as a kid. He had done all that, but all those registered rights had expired. because they were registered only for a limited period of time, 25 years. So the only law that he could use to stop this guy was copyright, which lasts for much longer than 25 years, as we'll talk about after the break. So my question to you guys, and I'm going to stop there, and Anastasia, have a break, and everyone can answer me afterwards. And I ask you not to Google the answer. Was it art or was it just an industrially produced object? Anastasia.
Yeah, so we can do a 5 or 10 minute breaks.
10 minutes would be ideal, I think.
Okay. Yeah, so we have 10 minutes for a short stop. Також ми маємо запитання від пана Лідіейта. Прикладом чого, на вашу думку, попросив не гуглити, є форма у зоряних війнах? Це витвір мистецтва чи об'єкт масового виготовлення? Ваші відповіді можете писати у чаті або розп'ютитися і відповісти, коли закінчиться перерва. Так, зараз 15:07. О 15:15 просимо вас вже повертатися. Дякую.
Друзі, а якщо не знаю, що це зоряні війни, що там насправді може бути мистецтвом чи не мистецтвом?
А це питання, знаєш, чутно мене, де?
Да, я просто не бачила цей фільм.
А, ти не бачила? Ну, дивись, ти можеш загуглити «Штурмовик зоряні війни», і воно тобі покаже, там така специфічна форма, така біла, але це питання, наскільки, дивись, фактично це розробляла команда, я точно знаю, що це розробляла команда людей, тобто це, може, і не один навіть митець це придумував, це команда зробила під кіно. І ну, я так, оце правда, що в Британії і в Штатах будуть, мабуть, різні закони щодо цього. Тому що, ну, в Штатах, я знаю, дуже жорстко. Там не можна копіювати все, це там купа була справ. Що...
Розкажи, Олександра, розкажи, що це за форма? Це якась
Давай я
дивна...
зараз знайду. Давай зараз тобі. Я прямо сюди зараз скину картинку. Хочеш?
Так, ну, всім можна скинути. Да.
Я всім скину зараз. Це ж... я так розумію, що це йде зараз. Трупер, Star Wars. Так. Аж так, а може статтю? Ну, дуже впізнаваємо. Її, до речі, використовували в українській політиці. В нас же був Дарт Вейдер, да? От це теж цікава історія. Зараз я знайшов цей трупер. От я бачу, що його можна придбати де завгодно. Я вже бачу тут купа всього. А хоча, от знаєш, вони трошечки відрізняються, я так розумію. Це обходять вони закони якраз. Окей, зараз кидаю це. Так, оце раз. Зараз буде 2.
Тобто от цей костюм, да?
Ну, от зараз я кидаю, зараз я... Давай отак посилання зроблю зараз.
Ні, ну просто йдеться про цей костюм, да? От це біле.
Да. От дивись, друга, от повністю там показано оце друге посилання. Ось. Бачиш, да, який костюм?
Угу.
Ось, я зараз зберігаю.
О, вау.
Ось. Це дуже впізнаваємо. І насправді я можу сказати, що використовується, це дуже популярно. Це настільки масова індустрія, що цих костюмів продано величезна кількість. Але ж вони придумані саме в зоряних війнах. Ну, це цікаве питання. Я думаю, що це витвір мистецтва, тому що, принаймні, це витвір дизайну, і він має охоронятися, тому що це придумали певні люди для певного комерційного проєкту в Каліфорнії. Тобто там є в них закони, і Америка от буде використовувати цю конвенцію для того, щоб контролювати по всьому світу. Хоча є дуже схожі, от я дивлюсь зараз в Гуглі, От це як обходять? Наприклад, от зробили його червоним. І все, червоний вже це не воно. І, до речі, ось на чому він базується. Зараз я покажу. Я зараз покажу вам, на чому це збудовано. Дивись зараз. Так. Your computer. Так. Оце оригінальне. Star Wars. Так. Є там, да, видно файл? Оце Star Wars. А оце друге, це на чому воно базовано. Так, зараз. Ага, от ви зрозумієте, просто це побудовано на самурайському костюмі. Просто його зробили футуристичним. Це самурайський костюм, просто він футуристичний, такий от такий от зроблено. Так. Видно там, да? Краще лінки. Ну, зараз я лінки скину. Ну, перший лінк точно є. Зараз я другий лінк скину. От, наприклад, copy image address. Так, оце.
Алло?
Ось. Так, якщо це витвір мистецтва, це може бути лише скульптура, і чи міг суддя визнати це за скульптуру. Але це також дизайн. Це
Нам же
дизайн.
сказали не гуглить, Олександр, ти що?
Ні, ну що,
просто-
я не гуглю, почекай, я нічого не гуглю.
Вау, яка, вау.
Я не гуглю, я гуглю тільки лише картинки, я не гуглю про цей
Ну,
стар...
добре, дивись.
Я
Ага.
нічого, я чесно все. Да, я включу відео собі, о.
Так, а ти кажеш, що попродавали цих костюмів, власне, отакої от пластикової, чи просто ляльки?
Пластиковий костюм прямо на людину. Так, блін, зараз я вам покажу фокус. Українська політика. Зараз. Я не гуглю, я не хвилююсь, насолоджуюсь хвилею мистецького життя.
Друзі,
Зараз.
можна запитати, хто дивився нашу п'єсу? Друзі. Не слышу.
Я
це
дивилася,
постійно-
я передивлялася рази 3. Вибачте, я просто пішла собі чай готувати. Клас.
Серйозно? 3 рази?
Ну,
Ой.
Приємно чути.
можна цитати розбирати, але втіна тепер.
Блін, там, знаєте, одна цитата, яка трошки загубилася, але я просто так хочу її зараз сказати. Там, ти англійський в школі учив, ти трубіш, або ти летиш в трубу. Але це просто, ну, не сказали через те, що всі отримали ці папірці, і треба було, ну, якось сконцентруватися, згадати і прочитати. І ні, не вийшло, але от цього не було. І там ще декілька теж загубилось, мені там серце
Так.
болить, але, ну, не можна ж все.
Показую. Я кидаю
Давай.
лінки на відео. Зараз. Так. Кидаю лінки на відео. Українська політика може насправді...
Боже, йому буде це дуже цікаво. Я
Пан
думаю.
лектор, може, не знає, але зараз буде цікавий кейс. Армія
Ну,
Дарта
то-
Вейдера захватила Одесу. Зараз.
Ну.
О! Вам чутно?
Так, кидай, да.
Ні, ти маєш поширити звук комп'ютера, а можливо тобі не дає ширити, бо ти не хост.
Та нічого.
Да.
Я вам скидаю лінки. От другий лінк особливо, подивіться.
Ти можеш
Другий
ширити екран, а можеш ширити тільки звук комп'ютера. Коли ти його шериш, то нам було б чути.
Та ви
Та, блин,
подивіться.
там такой какой-то ролик идет, там рекламы дофига.
Ну,
Дивись.
переключай рекламу.
Та прям переключай. Вау, я бачу це! Капець!
Оце, насправді, питання, в мене завжди було питання, наскільки вони можуть використовувати ці костюми, да, в комерційному проєкті, бо це політична партія, це фактично
Так, а
комерційний проєкт.
Ти скинув? Я думаю, що зараз Генрі теж подивиться, він навіть і не знає.
Ну, ми розповімо, ми скажемо, в нас в Україні свій от такий прецедент є, дивіться, просто прозорі новини багато.
А якщо він не захищений, чому вони не можуть його використовувати? Тобто, чи
Так
вони...
ми ж зараз дізнаємось,
Мгм.
правильно?
Угу.
Тобто, мені
Ми не
здається, може бути копірайтом, дизайн тільки промисловим патентом може бути захищеним, а не може копірайтом.
От наразі,
Так, зараз пан Лідіейт, він відповість на це питання, буде розповідати, яка саме була позиція у суду стосовно цього кейсу.
Так, може засудити піратську партію України на все життя, і вони будуть це графіці відмивати все життя в Україні. Дарт Вейдер в костюмі.
Якщо б я вела проект, де були такі костюми, я б їх промисловим захищала патентом. Ну, просто, а не авторським правом.
Я не знаю, я чесно, я гублюсь, тому що я не буду гуглити, я не розумію. Ой, там, дайте я. Ну от.
Так, Юлія. Так,
А ви знаєте,
зараз
друзі,
обов'язково покажемо пану Лідіейту також цей кейс, щоб він прокоментував.
Але це ж такий самий принцип, наприклад, ви купуєте якусь сукню від відомого модельєра, пошиту штучно, виключно під вас, а потім робите там фотосесію в цій сукні, в цьому одязі, костюмі. То, ну, яка може бути до вас претензія, якщо ви купили цей костюм? Ну, я не бачу в цьому такого щось. Тобто, якщо ви чесно купили той костюм Дарта Вейдера, а якщо ви не можна використовувати ім'я Дарт Вейдера, да? Тобто тут є, мабуть, порушення права, бо це є персонаж. А от костюм, ну я купив костюм, хочу фотографуюся в ньому, я ж чесно його купив. Тобто я використовую, ну, те, що захочу. У нас така ж сама штука з цими хангами зараз, з музичними інструментами, бо судять усіх майстрів, які роблять копію. Хоча насправді самі розробники, там Фелікс і Сабіна, вони зробили це зі сталевих барабанів Тринідад і Тобаго. Тринідад, Тобаго, індійський готам, китайський гонг, вони поєднали всі ці інструменти в одному. І, тобто, вони, можна сказати, щось вигадували, можна сказати, щось і не вигадували. Так, вони запатентували, наприклад, марку сталі, з якої виготовляють. Ну, а ніхто й не роблять ту марку сталі, роблять з інших марок сталі. Але чомусь вони визнали, вони ж, ви кажете всі, музичний барабан, ханг-драм, але він не є. Фішка в тому, що вони реєстрували його як музична акустична скульптура і заперечували, щоб називали його музичним інструментом. І тут є певний такий подвох, і ну, зараз вся спільнота у нас, ну, хто займається органологією, трохи схвильована, бо дуже багато позовів до майстерень, які виготовляють ці інструменти. От така ж сама фігня. Дякую.
Цікавий кейс, дякую, що поділилися. Ми будемо повертатися до лекції. So Henry, we had a pretty burning discussion here, and one of the reasons is that in Ukraine we have an interesting case. We have an internet party, so political party, which was using also stormtroopers' costumes and the costume of Darth Vader for a promo video. So it's the last link in the chat.
Oh, how interesting! Yeah.
Yeah. So in that case, whether they can be sued for using the costumes or not.
How interesting. And that case is ongoing, or has it been decided?
It's just the case. There was, as far as I know, there was no litigation in the process.
Oh, right. Okay. I think that, yeah. I mean, yeah. Yeah. Okay.
May I explain this story with stormtroopers?
Yeah, please.
Well, yeah.
Well, as a journalist, I'm monitoring this case. The story is that it's political technology which connected with party of regions. It's pro-Moscow party of Ukrainian pro-Moscow party and Russian policy technologists. They decide to make some kind of joke and to said that let us all the politics are very boring. Let us vote for new politics, you don't know who is it, but it's a Darth Vader and he's cool. And as for me, I think it's copyright violation, because they don't only use the costumes, but also use pictures, the image, and the idea and the
characters, the pure
characters,
characters.
yes.
Is there a question there, or that's interesting to hear it?
No, it's just like a commentary.
Yeah, okay, thank you. I think that my response would be using the laws relating to literary characters that are developed through characters rather than images. In other words, literary characters, named characters, whether it be Darth Vader or Luke Skywalker, they have a different kind of protection under copyright laws, under literary copyright, dealing with the protection of characters and names of characters that appear in literature and or in film or television. And they are protected in a very different way to actually what this case was about, which is about the shape, form, configuration, blah, 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 of the uniforms.
Yeah, and we have some other comments in the chat. The last one is
Yeah.
if the production company acquired the right to use, so it's kind of the same as buying an illustration for the packaging. So the author of this commentary supposes that the illustration is still the work of art, but the rights to use it are already sold out.
Okay, thank you.
But the majority agrees that it is still a work of art.
Okay, yeah, okay. In answer to the question I posed before the break, is what do you think in this particular case, just narrowing it down to this stormtrooper case and the uniforms, I can say to you that the UK Supreme Court decided that the stormtrooper uniforms were not works of art protected by copyright law, were not sculpture. They were merely industrially produced, what they call props or uniforms in the film. The film was a work of art, yes, under film copyright law, but the actual uniforms themselves were not works of art. They were simply mass-produced objects for use in a film as costume, and therefore the court ruled that Lucas did not own copyright in them because they weren't works of art, and therefore he lost his case, and that was the end of that. So that was the decision. You may or may not agree, but that characterized, if you want to look it up, they explain why. Okay. Now I want to move on. Sorry, my screen's frozen because it's been just sitting there for a while. There it is. Should be able to make it move. Okay. Now I want to talk about originality, which is what we were talking about before the break, and talking about the Bridgman Art Library. Just very simply, and this is a very important leading case, although it's 1988, it's still a very leading case throughout the Berne Convention world, which is very simply this, that the Bridgman Art Library was a library that used to hold photographic images, mainly photographs, which it then sold as a stock library to say to anyone, if you want a photograph of something, we can supply you with an image. And eventually the so-called stock library or photographic library eventually started, you can see there in the 80s, started to put them all their images online. Okay. And so their images, their photographic images, which were now digital, they created a digital bank, were included not just photographs, which were digitally available, but also photographs of artworks. In other words, photographs of paintings, photographs of illustrations, photographs of drawings. And the issue arose because although they had this image bank digitally available in the very early years of the internet, this Coral Corporation, which was based in Canada, decided it was a really good idea to have a digital image bank, and they would like to go into the business of selling images, digital images to people. So what they did was, I don't quite know how they did it at the time, but it doesn't matter. They somehow hacked, I'll say hacked, I don't know whether they actually hacked, they found a way of downloading Bridgman's images from its site. But remember, this was in the early days of the internet. And they downloaded all Bridgman's images and created their own website and set themselves up as offering these images, these digital images, which they got from Bridgman, in competition with Bridgman, and offering them for sale, for use, at lower prices than Bridgman were asking for them. So that was the basic situation. So Bridgman wanted to stop and brought a lawsuit in New York State against the Coral Corporation, who had some offices in New York State, using US copyright law to say, cease and desist, you can't do this, and we want compensation. You must stop doing this. You're using our images. And the first stage was, very similarly to Star Wars, is to say, does Bridgman own copyright in its digital images on its website before discussing whether or not Coral Corporation had used them by way of reformatting for their own purposes. So the issue narrowly came down to, is a digital reformatting of an image, whether it's a photograph, or whether it's a painting or an illustration or any other graphic work, if you create a digital version of it, does the creation of the digital version of it create a new copyright? Because as we saw in the previous slides, if you take a photograph, it's a copyright work that's recognized by the law. So Bridgman was saying, we took digital photographs of everything we owned and we put it up on our website. So we own copyright in those digital images. And Coral was saying, no, you don't, because you don't own copyright, because those digital images are not copyright protected works. Why? Because they don't pass the legal originality test. Why? Because they are simply the very best replication or reproduction of the original the original images, whether they be photographic or painted or graphic. And the digital image simply is as perfect a copy as can be made of an original. Therefore, the digital image does not pass the originality test, because the digital image is not an original image. The original image is in a previously existing format. So all you've done is reformatted it. You've not created a new digital image. That was the argument. And the court decided, and this is why it's such a leading and important case, is that it failed the originality. The digital image failed the originality test. A photograph of a two-dimensional work does not create a new copyright, because it's not a new image. It may be a new format, but it's not a new image. The image is still the same, as best as it ever was before. Therefore, Bridgman does not own copyright in its digital library, and therefore the case failed, and that was it. And that was the end of it. And so it's a really important leading case. The takeaway point is, if you make a photographic version of a pre-existing artwork, you don't create a new copyright in the new photograph, because you are simply reproducing an original image and you're not creating something, a new image. That's the lesson there about originality.